Hello everyone, this is Brian Ka with another video on Brian Ka Video. So this is a real property question, I believe from 2014 February exam, and I am going to just go over this question in case there are any people who are struggling with this subject. And believe me, this is not an easy subject for me either because there's so much studying and there's so much memorizing to do. It's almost like learning a brand new language, and a lot of it has to do with just rote memorization and also internalizing all these concepts because memorizing is hard, but if you can kind of make everything make sense in your brain and kind of just internalize everything instead of just rote memorization, I think it may be a little easier for you. But every person works differently, their brain works differently. So I guess you have to find the best way for and see how what the best way is for you to learn because everybody operates differently. So without further ado, let's attack question number 4. So Jane owned a machine shop and had one slightly buckled wall. It had been built years prior to town's adoption of a zoning ordinance that permits office buildings and retail stores, but not manufacturing facilities. Okay, so it already had a slightly buckled wall. Okay. Ira purchased the machine shop from Jane for 500,000. He gave her 50,000 in cash, promissory note for an additional 50,000 secured by a deed of trust. He borrowed the other 400,000 from Acme, which recorded a mortgage. Acme was aware of Jane's promissory note and deed of trust prior to the close of escrow. Donna owns a parcel adjoining Ira's machine shop. She recently began excavation for construction of an office building. Ira complained to Donna that the excavation was causing the shop's wall to buckle further, but she did nothing in response. Shortly thereafter, Ira's machine shop collapsed. Ira applied to town for a building permit to rebuild the shop, but town refused, and then he defaulted on his obligations to Jane and Acme. Ira has sued Donna seeking damages, and he has sued town seeking issuance of a building permit. Acme has filed a foreclosure suit against Ira, and Jane has demanded a proportionate share of the proceeds from any foreclosure sale. Nemo, shh. All right, I have a pit bull, and she's not happy right now. Anyway, so what's question number 1? How is the court likely to rule on Ira's claim for damages against Donna? Okay, so let's see. Ira versus Donna, right? And why is he suing for damages? What happened? He complained to Donna that the excavation was causing the shop's wall to buckle further, but she did nothing in response. Okay, so his shop buckled, and then what happened? Shortly thereafter, Ira's machine shop collapsed. Okay, so this should trigger a concept in real property, which is called lateral support strict liability. How exciting. Okay, so what is lateral support strict liability? Well, if the building or structure next to the plaintiffs would have made the plaintiff's structure to subside even if there were no structures erected. right? Defendant would be liable to the plaintiff. No, I would say it would be strictly liable. What this means is that if the building was what caused plaintiff's building to collapse without any changes in the land, defendant would not be liable, strictly liable. But again, if the movement of the excavation caused plaintiff's land to subside, which caused the building to collapse, defendant will be strictly liable. Secondly, plaintiff would have to prove that defendant's excavation was the cause, in fact, of the collapse of his building. I don't know if this is the best way to write the rule, but to explain this, if the neighboring excavation work made the plaintiff's building to collapse, but then if it didn't have any effect on plaintiff's land, then defendant would not be liable or strictly liable. But if the neighboring land or defendant in this case was excavating, and if that excavation caused the plaintiff's land to subside, right? If it caused this plaintiff's land to move or vibrate, and if that caused plaintiff's building to collapse, then defendant would be liable for strict liability. The second element that plaintiff would have to prove is that the defendant's action was what caused the collapse of the building. Maybe it could be cause and fact, proximate cause. The bar answer didn't do both. It just said general causation. It didn't go into proximate cause or actual cause. But I don't think it would hurt you to talk about proximate cause or actual cause. In this practice, for the purposes of saving time and just kind of just skimming through everything, I'm not going to go into detail, but generally, I would assume that these two elements are necessary to prove strict liability under the lateral support doctrine. So, Ira would argue what? Building did not buckle as much as now. That proves that the excavation caused his land to subside, further causing his building to vibrate. And then what happened? Further causing the collapse. This is just an example. Donna would argue the building was already in shambles. I wouldn't use shambles, for the bar answer, but that's what I'm just trying to make a point that it was already in poor condition, right? Um, Also, Ara does not have direct evidence showing that the that her excavation work affected his land underneath. Without showing this evidence, she would not be strictly liable. And then you have to conclude, as always, Donna may have a stronger argument here without more evidence showing that Ara's land was subsided as a result of Donna's work, excavation work. It is unlikely that court will side with Ara. Therefore, Donna would not be strictly liable in this case. Um, Again, I can do better, but I'm trying to do this fast within an hour. I'm trying to make a point, show you how I derived at this answer. That's the point. I'm not trying to, you know, obviously, I think this will be a passing essay, uh, but the point is, I can do better than this if I didn't have to talk as much and just solely focused on writing. But nonetheless, I think to show you uh, that I can do this or you can do this. Uh, Either way, I think this will be a passing answer. I'm not sure if it'll be like, 85, but for sure, I think I can write a 70, at least a 70 answer for this question. So I identified the issue. I wrote the rule of law, and my analysis could be better. It would probably be longer in a real test situation, but this is good enough for now. Right? So the next thing is that, yeah, it's true that that Donna's excavation uh, wasn't didn't affect Ira's land, so because of that, she wouldn't be strictly liable. But you have to show the bar grader that Ira has alternate ways to sue, in which in this case would be under the theory of negligence. And as you know, negligence has what? Duty, breach, causation, and damages, right? And then you would just go through each element: duty, pause, graph, zone of foreseeability. Um, Ira's building was a neighboring building directly next to it. Any excavation work would, would have affected his building. And then breach. Obviously, I would expand upon these, but I'm just giving you a brief answer for the negligence section because I don't think I need to go over these again because you've probably done it more than 1,000 times in your tort class. What a reasonable person would do under the same or similar circumstances, right? Causation to cause, in fact, proximate cause foreseeability analysis. But for foreseeability, it's foreseeable that doing excavation work next to it would cause whatever, whatever. You know the whole deal. All right, let me outline these damages, collapse, building collapse. That's what I'm referring to. Loss of business, cost of moving, and so forth. And obviously, if you talk about negligence, you have to talk about comparative contributory negligence. And then you would talk about, what's the role of plaintiff's damages reduced by his own negligence, right? Contributory jurisdiction barred if plaintiff contributed to defendant's negligence in any way, right? So let's see. Obviously, I would separate comparative negligence and contributory negligence in a real life situation, but here it is. So for Ara versus Donna, he may have a lateral support strict liability issue. We defined the rule, but after analyzing, we came to a conclusion that he may not have enough, just because there was not enough evidence to show that Donna's excavation work affected Ira's land, which caused the wall to buckle, eventually leading to collapse. So sorry, Ira, you don't have enough. You can't prove, your case under the strict liability theory, but he has an alternate theory which he can pursue, which is negligence. And for negligence, obviously, we all know that we have to prove duty, breach, causation, and damages. That's why I talked about pause graph, zone of foreseeability, and even under the theory or another theory which says that everybody is a foreseeable plaintiff. Under both theories, Ira would be, or Donna would owe Ira a duty of standard of care, right? Breach, what a reasonable person would do under the same or similar circumstances, right? I guess Ira would argue that Donna should have done more, such as hiring a structural engineer, getting consent because of the nature of the work that she was doing with her neighbors, which includes Ira, getting her contractor to review the land underneath, whether or not the excavation work was fit for a for to proceed, considering the neighboring circumstances structurally. But because she didn't do enough, Ira would say that she breached her duty. Causation, but for Donna doing the excavation work, the building would have never collapsed. The opposing argument would be that the building was already in shambles, wasn't in good shape anyways. But the counter would be it wasn't as bad before the actual excavation work, so she should still be liable. In foreseeability would be it's foreseeable that doing any excavation work would affect the neighboring structures nearby or the land. And then damages, obviously, the cost of damages would be the building that collapsed, loss of business, if he had to move. Maybe he could include if he was injured, but doesn't say so. So basically, all these things under damages. Under defense, one would have to go for comparative negligence, contributory negligence, and say that if IRA contributed to the negligence in any way, he would either be barred depending on which jurisdiction he's in. If it's pure comparative negligence, he would receive damages minus his own negligence, even if it exceeds 50%. In other jurisdictions, if it exceeds 50%, he may be barred. So just go over that. But in the end, what we have is IRA claiming under both theories, one theory will fail, strict liability theory, and negligence theory, which he may actually succeed in. So conclude that, basically you probably won't have to write conclusion, but strict liability, no. Negligence, yes. Defenses to negligence, maybe. And just write this out, just like what I said. Strict liability, no. Negligence, yes. If you don't agree, no. And talk about defenses. If she should be liable, should IRA be responsible for his own negligence, if there are any? But that is up to you to argue. I don't think that they're testing you on what your conclusion is. What they're testing you is whether you know the law, whether you can apply the facts to the law, and whether you can analyze everything from the beginning to the end and arrive at a conclusion. But they're not necessarily looking for what conclusion you derive that. All right, so how is the court likely to rule on IRA's request the town issue a building permit? All right, so zoning ordinance, I guess to start this off, you can kind of just define what a zoning ordinance is. Each town, county, they may have a specific zoning ordinance permitting some to do business, some to do residential, commercial, manufacturing. It would depend, but that would depend on what the area zoning ordinance may be. The key issue in this question is that should should IRA get an exception, right? Because what happened here is that IRA was he applied to town for a building permit to rebuild, but he was refused, right? So they're asking, how is the court likely to rule on IRA's request the town issue a building permit? So we have to find out what methods IRA can use to argue that he should get this building permit. And there are two ways to do this. The first is variance, right? Oops. And there are two types of variance: use variance and area variance. So use variance would be like if the wall should be erected at 6 feet. I want to, argue under use variance that I'm going to build at 6 feet 3. That would be like a not a substantial deviation, but like a slight deviation from what's permitted. But when it comes to area variance, it would be like the area is permitted for retail, but you want to argue that you want to use this area or your business as a manufacturing business. So that would be like an area variance. So what is it in this case? Well, IRA is arguing for manufacturing permit in a retail area, right? So this would be area variance. So you would basically talk about like, let's see, look, it had been built years prior to town's adoption of zoning ordinance that permits office buildings and retail stores, but not manufacturing facilities. So, in order to be eligible for area variance, you'd have to prove that the person not getting the permit would face extreme difficulty or hardship and would not affect the value of property, neighboring property, or harm it, right? So, in this analysis, uh, Ira would argue what? Obviously, financial difficulty, the cost of moving and uh, exceeds his budget, and he would lose all his businesses because his patrons only know of him through his physical location, and just make a bunch of stuff that Ira would argue to get this zoning variance. And that would be like, moving would create significant harm. He would be faced with financial difficulties that he can't overcome. The cost of moving exceeds his balanced budget. So, all these things, right? And then the second thing is his manufacturing machine shop would actually raise the value of the town instead of decreasing it, and also would not harm but benefit those around, right? Because he has to prove that the town itself is not going to the value of the town is not going to decrease as a result of his zoning variance. I guess you can counter town would counter saying, machine shop in a retail office location creates lots of noise, nuisance, blah blah blah, right? That would be the counter argument by the town. So, and then you would conclude that, conclusion, either town permits or not permits. I would go with town permits. So, but then you're not going to write town permits, but you would write the town permits because in consideration of Ira's argument, it's more reasonable to let his type of business, since he's not going to create chaos or more problems down the line, and since he has been in existence for many years, contrary to what the area zoning ordinance was, there has been no complaints by neighboring people, so it should be permitted, right? So that's the first thing. The second thing is non-conforming use. He would argue under this theory that it was once um, permitted in the area, or the restriction or the new ordinance did not exist, and therefore he should be given the new permit, or if not, be given amortization period so he can prepare. You know, obviously, you know, asking for time to prepare is not his best argument, but just in case they decide not to, grant non-conforming use doctrine, or non-conforming use permit, at least he can argue that he deserves to get a amortization period, and because of that, he should be given a leeway in time to prepare. So, under non-conforming use, you would either argue that IRA should or shouldn't be able to get it, but I would say that I should be able to argue that he should get a permit. So under variance and non-conforming use doctrine, RS should be able to get a permit to build his business again, right? So that's number two. Okay, so we went over lateral support, strict liability, negligence. We went to zoning ordinance, use variance, area variance. We decided that this was area variance issue, face extreme difficulty or hardship, wouldn't affect the value of neighboring property or harm them. We also talked about non-conforming use. So the third and the final question, and then let's see how much time we got. All right, we did this in like 30 minutes because we're not writing everything down like fully. So this is good. So Jane's foreclosure sale claim. No. No. Okay. So the question is asking, should Jane receive a claim because Acme initiated a foreclosure claim because IRA defaulted on his loan, right? But the problem here is that we have both the bank, Acme, and Jane initiating foreclosure at the same time. So what they're asking is who should get priority, you know? So the thing you have to know about that is that, in a foreclosure proceeding, priority goes to purchase money, interest, and whoever recorded first, right? And I'm just talking about priority here. So what happened here is that Jane, 50,000 promissory note. Acme, 400 loan, right? Because Jane received 50,000 in cash and 50,000 in promissory note. But cash, we're not dealing with cash here. We're talking about whether Jane can receive $50,000 from the foreclosure proceeding over Acme's $400,000 loan. Now, Jane's 50,000, was this purchase money interest? Purchase money interest meaning, was the $50,000 used was that used to purchase Ira's property? And the answer to that question is yes, because Ira purchased the machine shop from Jane for half a mil, gave her 50,000 in cash and a promissory note for another 50,000. So this 50,000, additional 50,000, which was secured by a deed of trust, went towards the purchase of the business. So this was a purchase money interest. Now, Acme's, was this purchase money interest? Yeah, because $400,000 was a loan, but that was used to purchase Ira's business. So yes, right? Because it was 50,000 promissory note, 50,000 cash, right? Because he paid 50,000 cash, 50,000 promissory note, borrowed 400,000 from the bank, so that was $500,000, 500,000 in total. So it makes sense. Now, the problem is that they're both purchase money interests, so they are both purchase money interest. So we cannot determine priority by strictly looking at, we must see who had notice, right? And here it says that Acme actually had notice, right? If this was a um, regular recording doctrine, then whoever recorded first would get priority. But in this particular case, I guess when it comes to purchase money interest, if Acme had prior notice of the promissory note by Jane, then Acme would not be the bona fide purchaser. So, if when you're not a bona fide, not a purchaser, but I guess in this case it would be bona fide foreclosure person who initiated foreclosure doesn't get the bona fide status because he or she or this entity corporation actually had notice. So when so even though Acme recorded the mortgage, they had notice, right? Because why did they have notice? Because here it says Acme was aware of Jane's promissory note, right? Just write Acme was aware of Jane's promissory note and the of trust, right? Because they had notice, Jane would still be the senior lien holder, and upon notice to the junior lien holder, which would be Acme in this case, the junior lien will get extinguished regardless of whether they get paid or not, right? And then priority of payment. Priority. So who gets priority of payment? Number one, fees, like attorney fees, fees for foreclosure. Next, senior lien holder, then junior. Rest goes back to the homeowner, right? So who's the so first fees would be paid out. Senior lien holder is Jane, and her um, promissory note was for 50,000, right? She would get paid first. Then the rest would go to what? Acme. And even though it is highly unlikely that there will be leftover money, if there was any, would go back to Ara. So, to the question that how is the court likely to rule on James' claim for a proportionate share of the proceeds from any foreclosure sale? Conclusion. In a foreclosure proceeding, the courts do not distribute money proportionately. Instead, it would use the priority rule mentioned above and pay the senior lien holder than junior, even though it will get extinguished. Then the rest will be paid to the homeowner. Alright. So the court, right. So the question whether James claimed for proportionate share, the the answer would be that in a foreclosure proceeding, courts will not distribute money proportionately, but instead would use the priority rule mentioned above. Priority and so so it is likely that Jane, as the senior lien holder, will receive 50,000 she had in deed of trust, and the rest to Acme that are. All right, so that answered one, two, and three, and we did that in 40 minutes. Now, the answer could be better, but the structure outline of this question would be this. And again, this is just a reference guide for you to compare your answers to another person, and also kind of look into how other people drive at their answer, what's their thinking or reasoning behind their answers. And this is what I'm trying to share, the fact that this is the way that I understood this particular question. This is the way that I would answer this question, even though it may not be a perfect score. Nonetheless, I believe writing like this would be a passing score because I basically did everything that the bar graders want, or at least very close to it, right? Maybe I could have done a little bit more to answer question three, just kind of expand upon it. Obviously, I could expand upon number two, variance, non-conforming use, and obviously, I could write like 3 pages on negligence, and lateral support strict liability is another area where I could have probably expanded everything and did a lot more writing on that subject. So with that, we were able to finish this question in under 40 minutes. I think that this was one of the easier ones. There are some questions in real property that are very difficult, but we will try to go through them so that you can watch how other people like myself do on these questions so that you can improve. And the final goal, obviously, is for you to pass the bar and become a practicing lawyer. So with that, I thank you so much for watching this video again. And until next time, I hope you study a lot, make sure to memorize all the black letter law, and if you're still in law school, make sure you're still kicking butt. Until next time, I'll see you.